Rolling. Thank you. Let's go on the record. Good morning, Board Member Stacy Moniz. I'll be presiding over today's proceeding. Also present, our Board Chair Marcus Oshiro and Board Member Cesnita Moipono by Zoom. Today is January 24th, 2024. It's approximately 9:05 a.m. We are here today regarding case numbers 23 CE 05976, 23 CU 05400, 23 CE 05978, and 23 CU 05398. In the matter of Donna Campbell, David Reid, and Cecily Therese Best. As complainants and respondents are Department of Education, State of Hawaii, and the Hawaii State Teachers Association. This is day 3 of the hearing on the merits. Would each party or their representative please enter their appearances for the record, beginning with you, Mr. Reid.
Good morning, I'm David Reid. I'm representing the complainants.
And also present with you
is Donna Campbell and Cecily Best.
Thank you. Mr. Takei.
Good morning, Board. Hiroyuki Takei for Department of Education.
Good morning, Mr. Takei. Mr. Alapa.
Good morning, Kiani Alapa for responding to HSTA. Also present is HSTA Deputy Executive Director Andrea Eshelman. Thank you.
Thank you, Mr. Alapa. Thank you. Good morning, Ms. Eshelman. I believe we left off with you, Mr. Takei, to continue with your case in chief.
Okay.
So you may proceed.
Thank you. I would like to call Mr. David Reid.
Mr. Reid. I'll just remind you, since I've already sworn you in, that you're still under oath.
Yes.
You may proceed, Mr. Takei.
Thank you. Mr. Reid, when were you hired by Department of Education?
Summer of 2017.
So you were never a new hire teacher entering the salary schedule in 2021 through 2023, correct?
That is correct.
When you were a new hire teacher, you received 6 years of credit for your verified non-BU5 service, correct?
Yes.
And this credit advanced you to a higher salary step than you would have been without the non-BU5 credit, correct?
Yes.
At the time of your hire, you were placed with in-service teachers with equivalent years of credited service, correct?
Yes.
Where did you work for the 6 years you got non-BU5 credit for?
I'm not entirely sure which of the 9 years they gave me credit for, but I taught 1 year in Obion County School District at the South Fulton Middle and High School. I taught 8 years in the Charleston County School District, 1 year, half at Stall High School as a choir teacher, and half at the band at the Military Magnet Academy. And then I taught the remaining 7 years full-time at the Military Magnet Academy.
I'm sorry, what state are these? Are these all separate states? Or?
Yes. No. Obion County was in Tennessee, and then both Stall High School and Military Magnet Academy were schools in Charleston, South Carolina, in the same district.
So okay, I'm sorry. Of the jobs that you described, what period of time are we talking about in terms of what year?
What year? South Fulton, 2008 to 9. And that was the Tennessee job in Obion County. And then Charleston, South Carolina was second half of 09 through 2017. 2017.
During that time period, you were not also a DOE employee, correct?
Correct.
And during that time, you were not a BU5 member with HSTA, correct?
That is correct.
And you did not receive pay from DOE during that time, correct?
Would have been nice, but no, I did not.
So during that time of 2008, 2017, that you were in Tennessee and South Carolina, you didn't experience the same step movements or lack of step movements that teachers in BU5 experienced during that same time period, correct?
I am not aware of what step movements did or did not happen during the time I was not living in the state of Hawaii.
My question is not whether or not you are aware of the step movements. My question is, you didn't experience the same step movements or lack of step movements within BU5 that teachers within BU5 experienced during that same time period, correct?
I lack the knowledge of what happened during that time period in the state of Hawaii to properly compare it to what I did experience. I would assume I did not.
Even without assumption, you could not have possibly experienced the same step movements or lack of step movements that occurred in a bargaining unit you were not a part of as a member in BU5 during that same time period, correct?
Correct.
And the opposite is also true, correct? BU5 teachers could not have experienced the same pay increase or lack of pay increase that you experienced in Tennessee or South Carolina during that same time period, correct?
Our experiences were different, yes.
And similar question, but during that time period, you did not experience the same effects resulting from DOE's recruiting difficulties that teachers within BU5 experienced during that same time period, correct?
There were some years where I did not get a raise in South Carolina. And my understanding is there are some years in the state of Hawaii where they also did not get a raise.
Again, it's impossible for you to experience the same effect resulting from DOE's recruiting difficulties, given that you were in a completely different state and not within BU5, correct?
Need some clarification as to what the effects we're talking about and what the recruiting difficulties are. As I said, I wasn't here during that time period. I wasn't involved with the union in information, so I don't know what the difficulties were or the effects.
Is it possible to experience the same effects felt by BU5 teachers during that time period that you are not a BU5 teacher? Are you saying that you can experience the same effects?
Are you saying, is it possible that I could feel the same way? Yes, absolutely.
Experience the same effects.
I experienced not getting a raise every year. I experienced the salary schedule used there being frozen, which what happens is is when you don't get a yearly increment. And my understanding is the contract says contingent upon funding from the state, there are to be yearly increments. So yes, I completely honestly believe my lack of step movement when I was in South Carolina, I felt the same effects of the teachers here in Hawaii who also had a lack of step movement due to funding.
Okay. Mr. Reid, what was your step placement? The year. The year that repricing was implemented, but before repricing was implemented. So I'm sorry, let me rephrase that. What was your step placement in 20? Sorry. Sorry about that. What was your step placement in 2022? Before repricing was implemented?
Step 8.
Okay. And what was your step placement in 2022 after repricing was implemented?
A very unhappy step 8.
What was your salary in 2022 before repricing was implemented?
I don't memorize that number.
Okay.
I had to guess around $63,000 or $4,000 a year. I also make a band director stipend of, at the time, it's $1,850 a year, I believe. Maybe 36.
At
the time, I believe I was class 4.
Okay,
Four.
thank you. Can you turn to E0041? This is the top base then.
Oh, 4.
Yeah. So this is your DOE history card report. With the years you worked with DOE, including your salary range and salary, correct?
It appears correct, yes.
Okay. If you look in the left-hand column, so we're talking July. I'm sorry. How do I describe this? 6 rows from the bottom.
Mhm.
And it says effective date, July 26, 2022.
Mhm.
Okay. And if you keep going across, you see the salary figure of 5,126.42.
Yes.
Was that your salary in 2022 before repricing?
I can tell you, I don't memorize the monthly amount. It does appear to be. I have no reason to believe that's not my salary.
Okay. And would you agree that this same figure was your salary after repricing was implemented?
Yes.
Okay. Thank you. So you would agree that before and after repricing, neither your salary nor your step changed, correct?
I would agree that the fundamental equation to determine my step placement changed and that my step did not change.
I'm sorry, I'm not sure. My question was just before and after repricing was implemented in 2022. Did your salary or step placement change?
No,
Okay, thank you. Now, you would agree. Oh, did you receive the collective bargaining agreement of 2020, July 1, 2021 through June 30, 2023? Are you aware of that particular CBA?
yes,
Okay. You would agree that that CBA, which includes the salary schedule, did not change in any way after a result, as a result of repricing, correct?
are you saying that the text of the CBA did not change as a result of repricing?
Right, including the salary schedule contained within it.
The document was not. Sorry. The text of the document was not modified. That is correct.
You're not aware of any replacement CBA that replaced this CBA, this particular CBA as a result of repricing, correct?
Correct.
Now, if you had more BU5 service, you would agree that. All right, let me rephrase that. Yeah. You would agree that placement on the salary schedule through repricing was based on your BU5 service only, correct?
To my great disappointment, yes.
Now, whether you were born or raised in Hawaii or on the mainland would not have had any impact on your step placement through repricing, correct?
Where somebody is born sort of determines where they live, and where you live somewhat determines where you work, and where you work, well, that determines where your experience comes from. So I would, what's your question? Do I believe, or what was the verb you used?
Whether, let me re-ask my question. Whether you were born or raised in Hawaii or on the mainland would not have had any impact on your step placement through repricing, correct?
I disagree. Now that I remember the first part of your thing, I'll finish of your question. As I said, where you are born and raised has a direct impact upon a lot of parts of your life, the sports you do, the activities you do, where you go to school, where you work, where you're comfortable. So being born on the mainland didn't guarantee, but it had a very strong, specifically being born in Kentucky, had a very strong influence on where I grew up, where I went to school, and where I worked. My first year of teaching was in Kentucky, and Tennessee. It was like 30 minutes from my house. We lived like right near the border. It was pretty much the same area. So I would say that where you are born and raised has a big impact upon your life and your experiences.
I thought you just said that repricing was based on BU5 service only.
Yes.
And so repricing was not based on where you were born and raised correct?
Correct.
Repricing was not based on the color of your skin, correct?
Correct.
Anybody can gain BU5 service through accumulating BU5 service, correct?
That sounds circular, but yes.
Let me phrase it this way. As far as you are aware, BU5 membership does not exclude on the basis of where you were born or raised or the color of your skin, correct?
Correct.
Now, I want to move on to, I would like to say the complainant's claims, but the claims filed in these cases. It's a preliminary question. Is it your understanding that each of the complainants here are, I guess, on the same page with respect to your understanding of each other's claims?
More or less, but I wouldn't want to speak for them. It's my understanding you're going to call them, so I would rather just speak for myself. But we are not in complete agreement on everything, but we are on agreement on most things.
Okay. Fair enough. One of your claims is that you allege DOE committed a prohibitive practice under 89-13A8 by violating the terms of the CBA, correct?
Yes.
And it's my understanding that that claim is based on your allegations that Article 20, Section E, Article 24, Section C, and Article 25, Section A were violated. Is my understanding correct?
Can I get a refresher on 24?
Sure.
I know the other two by heart. That one I'll use a. I don't have it here.
Yeah, you can use it. But I have a copy of the, wait. I'm sorry, that's the CBA, sorry. No, I don't need it. I confused myself.
No, I mean Article 24 of the CBA.
Okay, you are looking for the CBA, okay. Yeah. Yeah.
1, 6. Are you referring to Article 24 miscellaneous?
Article 24, so my understanding is that your claim of violation of 89-13A8 is based on Article 20, Section E, 24, Section C, and 25, Section A. Am I correct?
Yes.
Is there any other articles or section that I'm missing as your basis of your claim of of DOE violating 8913A8?
To the best of my current memory without looking at the complaint, yes, that sounds correct.
Okay, earlier in testimonies, Article 20, Section C came up, but is it correct that that is not
Oh.
part of the basis of your claim?
So I apologize. I said the best of my memory at the moment. Yeah, yes, Article C is Article 20, Section C is part of the claim.
You would agree that that claim was not you would agree that that section of Article 20 was never referenced in any of the complaints or pleadings in this case until the pre-trial conference statement, correct?
I've written an awful lot of pages over the course of this experience. I will say that as this experience has gone on, my understanding of the situation has grown at an alarming rate. And I believe that's an accurate statement, but as I learn things and as I absorb things and process things and understand things, this complaint, as I'm sure you've noticed, has slowly evolved over the last year. I believe you're correct, yes.
The answer is yes. It was not referenced anywhere
Prior to
the pre-trial conference statement. Right?
correct.
Now, can you turn to Article 20E of the collective bargaining agreement?
I'm here.
Now, you're alleging that the second sentence of that article was violated because repricing resulted in you no longer being on the same step as those with whom you were initially placed with the same years of service. Is that correct?
So my understanding of the second sentence of Article 20, Section E is, well, let me start with this, that a collective bargaining agreement is in effect from the first date to the last date. And the terms of the collective bargaining agreement should be enforced every day from the first date.
I'm sorry, may I stop you?
Well, you asked me if I understood, and I'm trying to tell you what I understand. I can do it now or in cross. It's
Mr. Takei, let him finish his
Okay.
question because you did ask him for his understanding and that's what he's trying to explain.
so.
I apologize.
Thank you. So as I said, my understanding is the CBA is enforced from the first date to the last date, and repricing happened within those dates. And second sentence says, those with prior experience shall be placed in the same step as in-service teachers with equivalent years of service, no more than 6 years. So my understanding of this is that that sentence was legally enforceable when repricing happened in October. So in October, that sentence, in October 2022, that sentence of the CBA was in force. And that sentence, again, I'm going to say, it's very short, but I want to read it. Those teachers with prior experience, which is me, shall be placed in the same step as in-service teachers with equivalent years of service. It says experience with equivalent years of service. The CBA says my experience is worth, my prior experience up to 6 years is worth up to 6 years of service that an incumbent teacher has. And that was enforced. My understanding is that was enforced, which would be between July 1st, 2021 and June 30th or 31st, I forget how many days were on that month, 2023. Therefore, it is my claim that I should have been placed in the same step as a teacher with 6 years of matching service to match my prior experience.
Okay, so you are alleging that the second sentence was violated because repricing resulted in you no longer being on the same step as those with whom you were initially placed with the same years of service, correct?
Yeah, the group that I was initially placed with and then got subsequent steps with, yes.
So you believe that the second sentence guarantees that you be placed on the same step with those teachers for your entire career. Is that correct?
Absolutely.
Now, are you alleging any other sentence of Article E to have been violated?
Nope.
Can you turn, we're probably the same page, Section C of Article 20. Are you there?
Yes.
Okay. You are alleging that this section was violated because repricing resulted in step movements. Is that correct?
Yes, it says there shall be no step movements, and it doesn't say negotiated step movements or non-negotiated. It just says no step movements or annual increments. I'm not really sure what that is during the period of the contract. Yes.
So yes, you are alleging.
Yes.
Okay. Mr. Bacon testified that that section only refers to negotiated step movements. Do you agree?
I do not see the word negotiated anywhere in Article 20, Section C. So I would say he is in error.
Okay, so is it your position that this section prohibits discretionary step movements through repricing?
I'm not sure we agree on the word. I'm not sure we agree on the meaning of the word discretionary. I will say that. That's what I believe. I believe that if this were to be violated, it would have required a waiver or an agreement or some written agreement from the Hawaii State Teachers Association.
Well, I'll take out the word discretionary and I'll ask another question. Is it your position that this section prohibits step movements through repricing?
Without a waiver? Yes. Oh, yes.
Yes, okay. Mr. Reid, are you opposed to repricing resulting in step movements?
So long as it is done equitably and fairly and in accordance with the law and in accordance with the contract. If the law and the contract is followed, I have no problem with repricing.
Isn't it your allegation that repricing resulting in step movements is a violation of Section C?
Are we referring to the specific repricing that happened in October 22 or in general?
The specific one that happened in 2021 through 2023.
Okay, so with that information, can you ask me again?
Are you opposed to that result? No, I'm sorry. My question was, isn't your allegation that the repricing that happened in 2021 through 2023 is a violation of Section C of Article 20?
Because I believe, and I believe there's evidence of that the repricing was illegal. It could not supersede Article 20, Section C.
It was my understanding that it was your desire to be included in repricing and having your steps increased. Am I mistaken?
I did desire for repricing to result in my experience to be recognized and my step to increase, yes.
Now, assuming that, let's say you are correct and section C doesn't allow for the type of step movements that resulted from repricing in 2021 through 2023, assuming that understanding of yours is correct. How do you expect to be included in repricing and have your steps increase if doing so would violate your interpretation of this section?
If it were done correctly, it wouldn't violate my interpretation of this section. If it was done under F1 and the union was brought into negotiations and they came to an agreement and the union was made to own their decisions regarding the repricing or made to own their position in the repricing, if they were negotiated and everybody's cards were on the table and everybody knew what everybody thought and it happened in the open, then and it was done legally, I don't have a problem with it. The way it happened, big issues.
Wouldn't it still result in step movements that you allege to be violations of section C?
If it's negotiated with the union, it should have a waiver, and that would make it not a violation of section C.
So you're saying that through negotiation, they would need to throw out Article 20, Section C.
I'm not sure that's the legal term, but yes. Supersede. Waiver of MOU of some kind to say it is okay.
Okay. So under your explanation, you would agree that if section C was not taken out, sorry, let me rephrase my question. Under your understanding, is it your understanding that as the PBA stands as it is right now, you would be asking HSTA to negotiate repricing that would violate section C?
If it's properly negotiated, it wouldn't violate section C. Like the union has the power to say, okay, we don't have to follow section C. But the union has to be asked in official negotiations. The union, I've studied a lot about a little bit, and this isn't, I think I have an understanding of this, but the union has the right to give a waiver. It's called a waiver or an MOU. The union has the right to say, okay, we're not going to, it's okay if we do this. The union has that right. And if it was negotiated, then they would have that, then they could give that right. Or if it were a legal F2 pricing with pre-established procedures for the repricing classes, and it was repricing solely as the result of the periodic review of repricing, then it's my understanding that the state could take their discretionary powers and do exactly that. But my understanding is neither of those two things happened. Therefore, I'm here today.
Can you turn to Article 24, Section C?
Yes.
Okay. Now, this is your allegation that this article and section was violated is based on your belief that repricing was inconsistent with the CBA. Is that correct?
Article 20, Section C speaks to the law. It says, except where contrary to the law, the agreement shall supersede any rules. My claim with regard to Section C is because the law was not followed under 89.9 F2, then except where contrary to law, this holds in force because it was contrary to law. Had it been a legal repricing, either with a waiver from F1 or with the proper homework, I'm a teacher, with the proper homework being done, or F2, either of those with the negotiation with waivers or with the proper homework being done for F2, then it would be consistent with law. And if it's consistent with law, then it can supersede the contract. It's my understanding. I'm not a lawyer. I've done a lot of Googling, but I don't think that resulted in a law degree. But my understanding is that, and since neither of those happened, Article 24 says this agreement shall supersede any rules, regulations, or practices of the employer. And repricing, is my understanding, is a practice of the employer that they are authorized to do by law. Minus the authorization, they can't do it.
Okay, so your claim of Article 24C violation is based on whether or not 89.9 F2 was used properly. Is that correct?
Correct.
Okay. And it doesn't have to do with the CBA?
Oh, I mean, Article 24, Section C is a CBA. That's the part that would say, unless the law overrides it. And in this case, the law didn't override it. So since it was overridden by an action, I perceived as illegal, I'm saying that C was violated because it was violated by a law, but it wasn't. So that's why Section C is.
I'm just looking for clarity.
Yeah.
So you're saying the violation was based on whether 89 F2 was used. Is there any other rules, regulations, or practices? I'm sorry. Is there any other law that you're saying that repricing was contrary to?
Several sections in chapter 89. You asking for the specific set? Well, they're in the complaint. 89.3. With regards to the employer. I don't have them all memorized. 89.3 is the right to have an employer organization. 89. Then there's if 13.1, I think. I don't have it. I don't think I have it in front of me.
Okay,
But the ones that I allege in my pleadings are the ones that I allege. I don't have them memorized. Yeah, all of them at least. A statement of the issues is complete. Well, the merit principle not being withstanding, that's also alleged. And to be clear, Article 25A, we haven't talked about that one yet.
yeah. Okay, yeah, please go to Article 25A. So here, you're alleging your rights, benefits, and privileges were violated, correct?
Absolutely.
And by rights, benefits, and privileges, you're referring to your rights guaranteed in the CBA, correct? Including your belief that you had the right to stay on the same step placement forever, correct?
Are you asking what I believe rights, privileges, and benefits pertaining to my conditions of employment are?
Yeah, on your claim.
Okay.
I just want to
My-
understand.
I believe my rights, privileges, and benefits of employment include any status gained, any gain, anything I gained as a result of the act of being employed is a right, privilege, or benefit of employment. Those three words are interchangeable, and they're there to be broad. On my understanding of those three terms is that they are there to be broad on purpose, to encompass anything I gain while in the act of being employed. And when I was employed, I gained step placement equal to a teacher, equal to an incumbent teacher with 6 prior years of service. I gained credits in the salary system. I reference an exhibit. And as the exhibits not that one, that's the wrong one. It's over here. No, I'm normally close. As exhibit E36, yes, that's the right year, 2017, 2018, says experience credit. Experience credit, and an entire paragraph that describes the requirements for 6 years of prior experience credit that I gained upon being employed. And up to 6 years of prior verified teaching experience. I'd like to point out the employers in E38 and E39, which is the employer's verification of my prior experience that was accepted upon initial hiring. And Article 25, in the absence, well, I have only found one definitive source. Well, actually 2, they both said the same thing. I'll mention where they came from. You can ask me though, if you want. The only information I have ever found in my life to define rights, privileges, and benefits of employment say any gain, any status, any interest, any account. It lists a lot more than what I said. I said the ones that pertain to me. And that is what I am alleging.
Okay, so by rights, benefits, and privileges, you're alleging things that go beyond the guarantees made in the CBA. Is that correct?
Yes.
I remember a question I wanted to ask about Article 24. Sorry, if you can go back to Article 24, Section C.
Yes.
It says, except where contrary to law, this argument, this This agreement shall supersede any rules, regulations, or practices of the employer which shall be contrary to or inconsistent with this agreement. The rules, regulation, or practices of the employer, that is specifically you are talking about repricing, right?
Yes,
Okay. Nothing else, right?
my understanding, yes, shall be
Okay.
processed.
Thank you. Now, to your second claim, you allege a violation of 89-13 A1. Correct?
Yes.
Mr. Takei, if you're gonna move on to another section, since we've been going for an hour, this might be an appropriate time to take a short break.
Sure.
Okay, so we'll take a break of 10 minutes and be back at 10:10. Thank you. Manager.
Yeah.
And we're back on the record. Mr. Takei, you can continue your examination of Mr. Reid.
Thank you. Do you have 89-13 in front of you?
I do.
Okay. So the next claim involves your claim that DOE violated 89-13A1, correct?
Yes.
Okay. And then, so you allege that DOE in some way interfered, restrained, or coerced you in the exercise of a right guaranteed under this chapter, correct?
Yes.
Okay. Can you specify which right under chapter 89 that you are claiming that DOE interfered, restrained, or coerced you?
89-3.
Is there any other rights that you are talking about based on A13A1?
I did not memorize my claims. To the best of my recollection, right now, direct violation 89-3. In reference to A1 and A7. So yeah, I don't have it in front of me, but to the best of my memory right now, I believe that is correct.
Okay, so your claim based on 13A1 is specifically you are referencing the rights contained in 89-3. Did I get you correct?
Yes.
Okay.
I don't have it in front of me, but I'm 99% sure that is accurate. Okay. That's when it starts by saying the employee shall have the right to self-organize.
Okay. Now, can you turn to 89-3, please? Oh, you don't have it?
That folder does, this one doesn't.
89-3. Okay, so would you agree that 89-3 contains a number of employee rights?
The number, yes.
Yeah, okay. Can you specify which employee right that you are alleging DOE violated in your 13A1 claim?
The employees shall have the right of self-organization.
Okay, would you agree that there is also employees 89.3 also includes the employee's right to form an employee organization for the purpose of bargaining collectively?
Yes, that is contained within 89-3.
Okay, is that a right that you are alleging DOE violated?
The right to form?
Yes.
No, the HSTA was already formed.
Okay. Do you agree that 89.3 includes a right for employee to join any employee organization for the purpose of bargaining collectively?
Yes.
Okay. Are you alleging that DOE violated this right?
Nope, I'm a member. I'm a due-paying member,
Okay.
active as I can.
Do you agree that 89.3 includes the employee right to assist any employee organization for the purpose of collective bargaining?
Yes, it includes it.
Are you alleging that DOE violated this right?
No.
Do you agree that 89.3 includes the right for employees to engage in lawful concerted activities for the purpose of collective bargaining or other mutual aid or protection?
Yes, that is included.
Okay. Are you alleging that this right was violated by DOE?
No.
Do you agree that 89.3 includes the right for an employee to refrain from any or all of such activities, which I think it's referring to collective bargaining activities, except for having a payroll deduction equivalent to regular dues remitted to an exclusive representative?
Yes, that is contained within 89.3.
Okay, so are you alleging that your claim of DOE violating 89.13A1 is related to this employee right? For your right not to engage in collective bargaining activities?
No, I'm not alleging a violation of that right.
Okay, so is it accurate that the only employee right that you are alleging was violated as part of your 13A1 claims is the right of self-organization?
Yes.
Okay. Now, isn't it true that you are self-organized under membership with HSTA?
I believe that is part. I am a member of the HSTA, and that is a part of the rights of self-organization.
Do you agree that HSTA represents all EU5 members, including yourself?
Technically, yes.
Technically?
Well, I wouldn't say they represent, well, yes. Yes, okay, sorry, my apologies.
Do you agree that HSTA as the exclusive representative is the only entity that can collectively bargain on behalf of EU5 members?
That is my understanding. Yes.
Do you agree? So you would also agree that you have no right to compel HSTA to negotiate any matter?
That is my understanding as given out in the board orders.
And you also agree that HSTA agreed negotiation was not necessary for repricing the one that was done in 2021 through 2023.
Can you restate that, please?
Sure. So earlier you agreed that you personally, as an employee, don't have a right to compel HSTA to negotiate issues.
Correct.
And so sorry, that wasn't my question. So you would agree, or is it your understanding that HSTA agreed negotiation of repricing, the one that was what we're all here for, was not necessary?
It is my understanding that the HSTA came to that erroneous decision.
Isn't it their right to decide which matters of negotiation is necessary or not necessary?
They do not have the right, it's my understanding, that they do not have the right to look at 89.9F1 and 89.9F2 and know full well that they've been asking for a repricing fix for 30 years, and then have the audacity to claim we didn't ask for this for the exclusive purpose so they don't have to publicize their decision to agree with the employer to not count our years of experience. They don't have the right to allow a de facto F1 repricing to happen and then call it F2 so they can say nothing we can do, it was done by law, the DOE is a big bad wolf, there's nothing we can do, when they have the resources, they have lawyers, they have consultants, they have legal experience in the house of the HSTA, that they knew the difference between F1 and F2, and they allowed the state to do they participated in a de facto F1 negotiation, and they claimed it was F2, and that allowed the union to hide from the fact that they agree, according to testimony yesterday, they agreed. Okay,
so
I want to finish that sentence.
oh, okay.
They agreed to, for the lack of a better term, throw us under the bus and at the expense of our 6 years of experience. That they did not have the right to do. I'm finished.
So you would agree that DOE didn't do anything to prevent you from self-organizing, correct?
The right to self-organize includes the right on the DOE side of it, includes the right for me, the right of self-organization includes the right for the state not to interfere with the processes that that organization is supposed to do. The state made the decision to violate 89.9 F2 by doing a repricing without having done the homework. That act circumvented all bargaining, all official bargaining. It circumvented any chance for the union to have to go on the record for throwing me under the bus. That act allowed the union to hide from the effects of that decision because it sheltered them from collective bargaining. And I have a right of self-organization under 89.3, and I believe chapter 89 is entitled Collective Bargaining in the Public Employment. And when the state made the decision to force the F2 negotiation, it interfered with the collective bargaining process. It interfered with my right to collective bargaining. My right to have an employee organization is illusionary if at any given point, the state and the union can say, we're not going to follow the law. The whole chapter is nothing if the sheep and the wolves, or both the wolves, decide they're going to eat all the sheep. The state is the wolf and the union is supposed to be the watchful wolf, and they both ate the sheep. It is pointless. This entire chapter is pointless if the organizations are not required to follow it. That's my understanding.
So at a minimum, we're at an agreement that DOE did not prevent you from joining HSTA, right? I mean, we agreed on that.
Correct,
right?
yes.
Okay. And you would also agree that that entire explanation that you gave is nowhere written under 89-3, correct?
Incorrect. Words have meanings. Words have meanings, right? Words have meanings. And the meaning of self-organization, it's my position that, and if I'm getting this wrong, I'm not a lawyer, but it's my case. It's the best. It's the best legal advice I could afford.
Yes. We'll stand in recess, 10 minutes.
Rolling.
Get back on the record. Mr. McKay, continue with your questioning of Mr. Reid.
Thank you.
Can I just add one little thing to what I started? I was just saying that words have meaning and the law has intention. I was reading the William S. Richardson student handbook yesterday, and there were a few quotes in the beginning, and one of them, I can't remember word for word.
Objection relevance, Mike.
This is my understanding of what the right to self-organization means and what the law means and how I'm clarifying my legal position for you.
I'm going to allow Mr. Reid to explain.
And I don't remember what it said exactly, but it left me with a feeling that the law seeks justice. And justice cannot exist when the laws are ignored. All right, there you go. Done.
Um. So based on your interpretation of the right of self-organization under 89.3, is my understanding correct that you are alleging DOE violated that right based on its use of 89.9 F2 over 89.9 F1?
Yes.
Is there any other act by DOE that you are alleging under your understanding of the right of self-organization
Um,
to which caused DOE to violate that right?
the best of my knowledge, that's correct.
Now I'd like to move to your next claim of that DOE committed a prohibited practice under 13A7. Can I turn your attention back to 8913, please?
Yes, I'm there.
Thank you. So 8913A7 states, well, it shall be a prohibited practice by DOE to willfully refuse or fail to comply with any provision of this chapter. Is that your understanding as well, the way I read it?
Yes.
Okay. Are you able to clarify which provision of chapter 89 that you are alleging DOE refused or failed to comply with?
It may seem a tad redundant, but like I said, it's the best legal advice I could afford. 89.3 again. It's yeah.
89.3 again, okay. Is there any other provision that you are basing your 13A7 claim on?
Like I said, I don't have the complaint in front of me. The complaint ultimately speaks for itself to the best of my I haven't read it in a while. To the best of my recollection, yes. Or if that's the only thing it's alleging. What was your question exactly?
So you said that 89.3 was
What it pointed to?
was the provision. What?
Yeah.
What did you say?
Yeah. 89.3 is what it pointed to.
Yeah, that you're alleging DOE refused or failed to comply with. And my question was, is there any other provision that you are alleging DOE refused or failed to comply with in relation to your 13A7 claim?
Well, he'll ask me that question. To the best of my current memory, once again, having not looked at my complaint in a while, and I've written a great many pages between now and then. Yes, that's correct.
Is There, I am reminded of a claim of violating the merit principle. Is that no longer a claim that you are alleging under A1, A7?
That- Thank you for reminding me. Yes, there's a claim that we're alleging.
Okay, is that a A1 claim
That
or a A7 claim?
I did look at it briefly this morning. My statement of issues, the first one with the DOE alleged, I believe it was either the 1 or 7, but didn't list which one it went to. One of those is probably for the merit principle, and one of those is probably for 89.3. So
Are you able to provide clarity on which one at this moment?
well, I don't know, as far as which numbered issue on the statement of issues. It's not in front of me right now, but one of them pointed to 89.3, and one of them I don't think pointed to anything. With probably an omission on my part. Once again, my legal assistant is kind of a slacker, and the one that doesn't point, because these are supposed to point to another part in the chapter, and the one that doesn't point to another part of the chapter is supposed not looking at it right now, but merit principle, yes.
Well, it is my understanding at least that the merit principle was raised, right?
Yes,
As a
yes,
claim.
yes.
But it's my memory that A1, 13A1 or 13A7 wasn't clearly designated. Are you able to designate it at this moment?
I would like to try. What do you mean exactly by designate?
So through the pleadings and complaint, at least to my understanding, the issue was raised, but it was never made clear whether or not you were alleging a 13A1 violation or a 13A7 violation. And just for clarity's purpose, I was hoping you could clarify.
I'm not sure I'm qualified. I mean, it is my complaint, but I'm not sure I possess the knowledge to offer you. I would like to if I could. I'm not trying to be difficult. I'm not a lawyer, and I'm not sure. I don't know how to express. I don't know how to answer. I don't know. Other than to say that yes, we alleged the merit principle. That was in the original complaint. I'm pretty sure. That all back to the first one. But I'm not sure I can offer you, just because it's hard for me to contain all the. When I'm actively writing a document and I'm researching in that exact second, it's more clear. Weeks, days, months after I've written the document and have the research in front of me, the details are a lot less clear.
Okay, well, would it be accurate to say that your merit principle claim falls under 13A1 or 13A7?
Yes.
Okay. Are you alleging a violation under 13A7? A violation of section 89.9?
It's my understanding I don't have standing to directly allege or accuse or whatever the legal verb is, violations directly under 89.9. Like I said, my complaint is in front of me, so I'm at a slight disadvantage. However, I will say that we are talking about 89.9 because the violations of 89.9 are evidence of the violations that we've just discussed.
I understand. So just to be clear, 89.9 is relevant you know, especially 89.9 F2.
Mhm.
But 89.9 specifically is not the basis of your 13A7 claim. I'm sorry, because you believe that 89.9 you don't have standing.
That is, I believe, what the board has ordered a few times on the motions to dismiss and summary judgment.
Okay.
Yes.
Mr. Reid, are you receiving help from an attorney?
No. Be nice though.
Okay, and I just have one last question. At no point did DOE prevent you from pursuing your concerns regarding repricing with the HSTA, correct?
Yeah, that is correct.
I have no further questions.
Thank you, Mr. TK. Mr. Alapa?
Yes, if I may. Mr. Reid, is it your belief and position that if the union demanded negotiations in this case, they would have forced the implementation of a compression fix that included the three complainants, including yourself?
Who is the they referring to? Is it they the union would have forced, or they the DOE would have forced?
Let me ask the question, addressing your request for clarification.
Okay.
Is it your belief and position that if the union demanded negotiations in this case, the union would have forced the implementation of a compression fix that included the three complainants, including yourself?
It's my understanding that negotiations do not compel agreement.
Okay, so then answer to my question is no.
No.
Based on that explanation?
Yes.
Let me get some clarification on what you're seeking here. As far as a remedy, are you asking the board to take away 55 million per year from 9,000 plus HSTA members and teachers? Or are you asking the board to readjust the steps for the three complainants to credit your non-BU5 time as part of the employer's compression fix?
So this is what the answer to your question is interesting, because this isn't I honestly don't know what the board can do. It's my understanding, based on reading decisions in other cases, there's a list of like yearly important or big cases that they do, and I've read through some of the decisions, and from what I gather, and granted this might be entirely wrong, but from what I gather, the board can force negotiations to happen. I read a case where the issue was negotiations didn't happen, and the result was they made them negotiate with respect to the proper context of the issue, and then there's an outcome. I frankly don't know what the board has the power to do or not do. I know that salaries are a complicated thing. I don't think they can just be dictated by three people. Maybe they can. I don't know. I really do not know.
Let me clarify it for you. Putting aside any legal conclusions as to what the laws or rules authorize the board to do, what is it that you want? And the options I presented were: you want them to take away the 55 million from the 9,000 plus members? You want them to force the inclusion of the three complainants in the compression fix? Or what is it that you want, irrespective of what the law says?
So what do I want? Just regardless to what I think can happen. I believe that something should happen that results in prior experience being counted. And I would like that, that prior experience being counted to be retroactive the same day that was retroactive for the, for everyone else. And that's what I want.
Okay, and let me restate as far as how I understand what you just said, your testimony. You can let me know if I'm correct. You're not asking the board to take away benefits from the 9,000 plus members who receive the benefit from the compression fix. You're asking the board to include the 3 complainants for their non-BU 5 times. Is that correct?
I would add one thing to that. I guess in my head there were 2 scenarios, one of which is probably more likely. So this may sound mean, but as my dad once said, if you're gonna do it once, better do it right. So if only because I think it would yield a higher chance for success, if sounds mean, if the compression adjustments were taken away from everybody, both the state and the union would be extremely motivated to renegotiate and reprice. I would imagine they would want to do it to the day the decision comes out, so that it gets fixed quickly. That way, and the second time after it's taken away, they'd be super motivated to get it done, and that would include us. So if only to motivate both parties to get this job done ASAP, I would have no problem with it being used that repricing has been reversed, but HSTA and the employer are negotiating as I type this article to solve it today, and that solution would include us.
Okay, so that's changed from the prior testimony. So let me try and get this clear. One of the remedies that you are asking for and are okay with is an order from the board requiring the 9,000 members who receive the 55 million plus to give back the benefits they receive. Is that correct? And force the parties into negotiations.
That would be, in my opinion, the solution that's most likely to result in the result I want.
Yeah, understood. Is it your belief and position that if the HSTA negotiated the implementation of the current form of the employer's compression fix, would you still have a claim? And you know, the question isn't framed correctly. Let me adjust the words. Let me ask it again. Is it your belief and position that if the HSTA negotiated the implementation of the current form of the employer's compression fix, you would still have a claim?
I believe that the claim would be weaker because it was assuming that they did it correctly under 89.9 F1 or 2, then my claim would be weaker, but I would still have a claim that my rights, privileges, and benefits. Sorry. Let me go back a step. Scratch. I probably wouldn't have a case. I don't know. I would imagine I probably wouldn't have a case if it was a legal negotiation with a waiver of my rights to those 6 years. And the reason why I think that would never happen is because the union would probably become enraged that
I'm not asking for a speculative scenario. I had a specific question.
Yes.
So, but no, it's a specific question. Let me rephrase it one more time with your answer to see if this helps. Is it your belief and position that if the HSTA properly negotiated the implementation of the current form of the employer's compression fix, you would still have a claim?
I'll be the much weaker one, yes.
What would still remain if they properly negotiated the employer's compression fix?
What would remain would be that I don't think the state has the right, or the state or the union has the right to take away those 6 years of credit. They can negotiate a waiver to give everybody lollipops on Monday, but I don't think they have the right to take. I think that is protected. I I think that is protected to a point that it would survive having a complaint.
What is the basis of the right that you believe is protected from taking away the 6 years of credit? What's the law? What is the CBA? What are you relying on that cannot be subject to a properly negotiated
Waiver.
agreement or waiver?
The 14th Amendment of the US Constitution is the, I've been honest, I looked at it, equal protection under the law.
Okay, so you're relying on the 14th Amendment for your answer.
If it were legally done, 14th Amendment, I believe, would offer me protection. It would not pass the strict basis test. It's been a while since I've read this, but you have to.
And I don't mean to interrupt you. You answered the 14th Amendment. The board doesn't have jurisdiction over the Constitution, but I got your answer. That's what you do. Right?
I think I've read that the board can see issues that involve that involve that particular. I don't have it in front of me. Haven't read it in a while, but I am confident that I have read decisions and board orders and that yes, they can.
Okay, well, we're not going to go into legal conclusions, but I got your answer.
Yeah.
You believe your remaining claim would be based on a right to the 6 years of credit under the 14th Amendment.
Yes.
Is that accurate? Okay. If the employer had established written procedures for the periodic repricing reviews pursuant to HRS 89F2, do you believe the employer's use of 89-F2 would have been appropriate in this case?
If they had done the homework, yes.
Um,
Their use of F2 would have been appropriate had they done the homework.
Okay, and if they had a written periodic, established periodic reviewing policy pursuant to 89F2?
If it met the same standards of all of their other written policies with regards to form and approval, and if it wasn't just written on a napkin, I wouldn't accept that. But if it met all the typical expectations for written policies, and they had the results exclusively from those actions, that would, in my unlegal opinion, make it a legal F2 negotiation.
Okay, and let me then add the terms formal and official to my question. Let me ask again. If the employer had an established written formal and official procedure for the periodic repricing review pursuant to HRS 89F2, do you believe the employer's use of 89-9F2 would have been appropriate in this case?
I object. I
Oh,
don't
no,
know what
wait,
Mr. Reid-
Miss-
Is he
Ms.
speaking for
Campbell,
himself?
Ms. Campbell,
Is he speaking for
Ms.
himself
Campbell, hold on.
Okay.
Okay, 1 second.
Okay.
Mr. Reid is testifying.
on behalf of himself?
You're gonna be able to
Okay, thank
testify.
you.
later.
My train got derailed. Can you ask that again?
Sure, and it's the same question, but I added formal and official. So let me read it again. If the employer had an established written formal and official procedure for the periodic review of repricing pursuant to 89-9F2, do you believe the employer's use of 89-9F2 would have been appropriate in this case?
Isn't that speculation?
Mr. Alapa's just asking you for your opinion.
No.
If you understand the question. you can answer.
I believe a repricing action could happen, but the repricing action might still contain illegal requests. Even if the homework was done, the request still has to be, can't violate rights. So if they had their procedures and they did their periodic reviews, they could do a repricing, but at the discretion of the employer, it doesn't give them the right to do whatever they want. So yes, with the caveat that it does not give them the right to do whatever they want.
Okay, so what about this particular compression fix? Do you believe that even if they followed the procedures of 89F2 would still be invalid?
I believe that the repeal of 302A-627A absolutely violates the 14th Amendment. I believe I could still complain that removal did not offer me equal protection. I haven't looked at this in a while, but that law was a very heavy measure, or that repeal was a very heavy measure to accomplish their mission. There are less, here's the words, there are less invasive ways they could have accomplished their mission, which would not have given up my equal protection under the law. And so I believe even with a legal repricing under 89.9 F2, maybe it wouldn't be in front of the labor board, but a legal repricing under 89.9 F2 that included not counting my 6 years, I believe would still be subject to the 14th Amendment equal protection of the law on the grounds that they accomplished no legitimate state function by that heavy-handed action of stripping me of my rights those 6 years.
Yeah, and based on your testimony, let me rephrase the question again to include your reservation that that claim still exists. If the employer had an established written, formal, and official procedure for the periodic repricing review pursuant to HRS 89-9 F2, do you believe the employer's use of 89-9 F2 would have been appropriate in this case, other than its repeal of HRS 302A, which you believe is a violation of the 14th Amendment?
If I understand your question correctly, I believe yes.
Yeah. Were you aware that there is an actual written policy?
No, I'm not aware.
Okay, board members,
I object to it.
let me finish.
He had a
Let-
deadline.
You can object, let me finish.
finish.
As impeachment evidence, I'd like to mark as Union's Exhibit C, I believe it's CU3, the State of Hawaii Department of Human Resources Development Policies and Procedures, policy number 201-007, entitled Periodic Repricing Review, which is publicly available on the State of Hawaii Department of Human Resources website, and I can provide copies for your review and for the party's review.
Once again, can I say my objection?
Yeah.
There were deadlines for evidence. I made very clear in the last couple of hearings exactly what my position on this was. There were deadlines, they were passed. We were not allowed to submit evidence. I think actually rather the decision is waited until we actually decide to submit them, which I guess would be now for you. But there were deadlines there, and deadlines mean something. And I object to the untimely introduction of any new evidence.
My understanding is that Mr. Alapa, correct me if I'm wrong, you're offering this for impeachment, not necessarily as an exhibit that's going to go into evidence. This is for impeachment purposes.
Yes, and it's directly related to a testimony that's provided throughout these past 3 days.
Can we see the document, please?
Should I provide to the other parties?
Yes, please. Yeah, please provide the documentation and then we'll take a short recess. And let the record reflect that Mr. Alapa has handed a copy of the document he's intending to use to all the parties and the members of the board that are present. We will take a short recess subject to call of the chair. Back on the record, Mr. Alapa, the board has conferred, and it's the board's decision that this document, it cannot be used or introduced into evidence at this point. And for the reason, even though it's not offered as an exhibit per se, that it's not relevant to this because DHERD is not the employer. It's DOE. DOE did the repricing, so it would have to be the established procedures of the DOE, or if someone would testify that this is what they relied on. However, which leads to the second point of its improper impeachment, because Mr. Bacon's testimony was there were no procedures. And I believe Ms. Eshelman said that she wasn't aware of any procedures. So we don't believe that it's proper impeachment, but I'll let you respond.
Well, number one, I think, I'd like to know if I can call a rebuttal witness for the employer's case. If not, I'd like to, to reserve the option to call a rebuttal in our case in chief. And it's a weird dynamic, but I know this is not my case. But I think important information is coming here that I think applies also to my case. Number two, I think, as an offer of proof, I'm not really concerned about what the employer did and what they followed. But as part of the union's due diligence, is to assure that there exists procedures. Whether the employer followed it, that's between the complainant and the employer. As part of our due diligence, as the testimony was showed during our case in chief, there was diligence done by the HSTA to assure that F2 was proper. And this is directly not only responsive to the complainant's testimony, but also to Mr. Bacon's, because he did give that testimony. So if we can't put this into evidence now, then I want to reserve the right to call a rebuttal witness.
And we will consider that at the appropriate time. I'm not precluding that, but right offhand, I think the board believes that if you're going to impeach someone with this, it would be Mr. Bacon, because he is the one that testified that there are no procedures, and not Mr. Reid. So I understand your point. And at least for this moment, we're going to deny the use of this document, but I recognize your reservation. If the issue comes up later, to call a rebuttal witness, but we are not precluding that at this point.
Can I then move for judicial notice on the DHRD-Hawaii.gov website, which is an official website of the Hawaii government? This policy is provided there with the representation that these policies are effective and in place. I understand the argument that we have to connect it and all that, but I'd like to request that the board take judicial notice on this, which is published on an official government website.
I understand that, Mr. Lapa, but again, I'm struggling with the relevance, because if this is the policy and procedures of the Department of Human Resources and Development, I understand that. But here we're talking about a separate jurisdiction and a separate employer, which is the Department of Education. If this was the policies and procedures of the Department of Education, the board would have no problem admitting this. And if I may add, well, I'll let you respond.
Could I just have a quick 2 minutes to confer with my client? That'd be really good.
Yes,
Thank you.
Mr. Takei.
Yes, I just wanted to clarify, the board just said Mr. Bacon testified that there was no established procedures. I believe what Mr. Bacon testified was there was no written established procedures.
That's fine. That's
Okay,
correct.
so it wasn't the board's conclusion that there were no established procedures. Can I?
Yeah, there were no written established procedures.
Okay.
But it's also this board's chair recollection that there was no discussion of any oral procedures either. So you are correct, Mr. Takei, but there was no offer into evidence of oral procedures that I can recall. I can stand corrected when the record shows, but I understand your distinction. It's noted. Yes, Mr. Alapa.
The 2 minute recess.
Oh, yes, sorry. We'll stand in recess. Ready? Back on the record. Mr. Alapa.
If I may supplement my request to take judicial notice, the testimony throughout the hearing has included testimony about the Office of Collective Bargaining being a part of the compression fix. They had decision making and they're part of the consultation. And the Office of Collective Bargaining falls under the Department of Human Resource Development. Also, the Office of Collective Bargaining is the bargaining representative for the governor, who also happens to be the ultimate authority for the DOE. So I do believe that this policy is relevant through the Office of Collective Bargaining, who falls under the Department of Human Resource Development.
If I just heard you correctly, you said the Office of Collective Bargaining had decision-making authority in this process?
And let me rephrase it. They were part of the decision-making process as testified by Mr. Bacon.
In the consultation process?
Yes, the consultation process, but ultimately the employer's decision-making process.
I guess, and I'm not trying to quibble, but I guess that's the part that I'm kind of struggling with a little bit. Is that where's the testimony from anyone that the Office of Collective Bargaining actually participated in the review and the repricing that was done by the DOE, that they had some kind of input or authority in the decision-making process? Because you would agree with me, DHERD is not the employer. The employer jurisdiction here is the Department of Education, correct?
Department of Education, correct.
Okay, and this is the policies and procedures of the Department of Human Resources Development, right?
Yes. And if I can address your question, there's
Sure.
a document that addresses your question directly, if I can
Sure.
pull that up.
And if you want, Mr. Olave, based upon your, as I understand right now, your offer is for us to take judicial notice
Correct.
of the existence of this document, and that it exists on the DHERD official website.
Correct.
Yeah, we can take judicial notice that this document exists on the DHERD website. And then it'll be up to the board to decide what relevance it has. So if that's your request for judicial notice that the document exists on the DHERD website and is part of the policies and procedures of the Department of Human Resources Development, we can take judicial notice of that fact.
Thank you. And if I just to complete the record, if I could just address your question.
Sure.
On Employers Exhibit RE1, page 3, which is date stamp E0010. And if you can let me know when you get there, for number.
What page is that again?
Date stamp top right is E0010.
I'm sorry. So is that E10?
Yeah, E10.
Okay, I'm there.
And so this is the October 6, 2022 memo presentation from Superintendent Keith Hayashi regarding the employer's compression fixed plan. On page stamp E10, the second paragraph in the middle to the right starts with to date. It states, to date, the implementation plan is a product of truly collaborative efforts between the department, HSTA, and the Department of Human Resource Development Office of Collective Bargaining and the Department of Budget and Finance. So that's where we get the Department of Office of Collective Bargaining's involvement in this case. And just to be clear, I'm not asking or any kind of finding that the employer followed it or implied it, for the union's case, this policy existed. Whether they follow it, that's between them.
No, I understand your position. I'm gonna let Mr. Reid respond.
It's my understanding, looked it up last night, I believe Rule 801, that impeachment evidence must speak to my character and my truthfulness.
Well, I'm gonna object.
And this-
You've already ruled on impeachment.
Oh,
Yeah,
sorry.
I already said it's not gonna be allowed for impeachment. Mr. Alapa then switched gears
Okay,
and requested
Thank you.
judicial notice.
so just one more thing, just to reemphasize it. I am not employed by the Department of Hawaii, it's a Department of Human Resources Development. And while they collaborated, the HSTA also collaborated with this. And if they're saying that this office had decision-making in that process, and by that matter, the HSTA had decision-making in this process. And I think that completely that is fatal to their argument that they use 899F2, is 899F2 is unilateral. That's just.
Well, Mr. Reid,
Yeah.
all the board is doing at this point with this document is taking judicial notice
Yeah.
that it exists. And that it's there and is part of the official website of the.
Yeah.
And at this point in time, nothing else.
Okay, that's what I said. Thank you.
Thank you.
No, you're welcome. So, Mr. Takei, are you ready to proceed? Oh, I'm sorry, Mr. Alapo is asking.
Yeah.
With all this back
You
and
heard enough
forth,
from
I
me
lost
already.
track. It's your turn, Mr. Alapo, sorry.
I just have a few more questions. Mr. Reid, do you agree that the collective bargaining agreement is not effective to the extent that it's contrary to law? Agree or disagree?
I don't understand. Can you say it a little slower? And
Sure.
Yeah.
No problem. Do you agree that the CBA is effective to the extent that it is not contrary to law?
I don't have the context to offer an opinion on that.
No problem. Are you a member of the HSTA?
Yes,
Were you a member of the HSTA during all relevant times relevant to your case?
yes,
And the HSTA was your exclusive representative during all relevant periods relevant to your claims?
yes,
Have you ever run for office with the HSTA?
yes.
When was that?
It was the last election was the Maui chapter. I forget if it was secretary treasurer or it wasn't president. It was I forget, is it president, secretary treasurer? What's the third? It wasn't president. It was one of the other.
If you don't know, I mean, I understand. You don't have to. It's okay. So what were the results?
I lost by 60 some votes.
Okay, so but you were allowed to participate and run for office.
Yes,
And I understand you were parts of or served on the new educator committee for HSTA.
it's been a few years, but yes, I think so. Yeah.
Okay, and you're allowed to participate in that way with the union.
Yes,
And no one prevented you from running for office with the HSTA.
correct.
And no one has ever prevented you from attending any HSTA meetings that's available to the membership.
No.
And no one has ever prevented you from voicing your opinion to the HSTA?
Nope.
Okay, that's all I have. Thank you.
Thank you. Mr. Alapa. Mr. Takei, you have any further questions?
No, I don't have any more questions for Mr. Reid.
This is sort of a cumbersome process, but I would suspect that Mr. Reid would have an opportunity to question himself.
Hence the problem.
So I'm going to allow Mr. Reid to give testimony. The only caution I'll give Mr. Reid is that your testimony should be limited to the areas covered by Mr. Takei and covered by Mr. Alapa.
All right. Can I confer with my complainants really quick?
Yes.
Charlie.
How long do you need, Mr. Reid? Do we need to take a recess?
2 minutes.
2 minutes.
2 minutes, very short.
We can stand in recess for 2 minutes.
Back on the record, can I just ask a housekeeping item?
Sure.
This is.
Back on the record, Mr. Alapa.
Just for housekeeping purposes, Ms. Eshelman, the complainants are gonna call Ms. Eshelman as a witness in the union's case, but she will be out of state on Friday. The original agreement with the complainants was, she'd be called for their case against the union on Tuesday, and obviously we're going a little long. So we talked about it briefly, I talked about it briefly with Mr. Reid, but if we can just assure, even if we have to take her out of order, that she testify at some point tomorrow, and I can also present my case at the same time if needed. When it's my turn to ask questions of her, if we can consider that for tomorrow, it seems like we are going a little longer than expected. I'd appreciate that from the board.
Absolutely. We'll accommodate Ms. Eshelman's schedule and whatever works for the parties to get her on by tomorrow, so she doesn't have to worry about Friday.
Thank you.
Not a problem. Okay, Mr. Reid.
I'll be brief. I spoke about the individual charges. I want to touch upon one of them just a little bit. Article 20, Section E, is where the source of the right to have my 6 years of experience is from. Every year or every contract that I've seen, I haven't seen all of the contracts, but I've seen all the contracts since I've been employed, and all of them state the same thing. It's a different letter sometimes, but they all different section, but they all state the same thing. The contract has a long-standing history of having those 6 years to be placed in the same step, and that is that is in effect for the duration of the CBA. CBAs are the terms and conditions over a period of time, not terms and conditions over the day you're employed, and not ever again. Maybe a traditional contract would need to state explicitly a contract that's valid and for a period of time. But this one is valid for a period of time. They are renewed, they are created each time, and each time it's being created, the expectation of, or rather, the expectation that teachers with prior experience should be placed in the same step as in-service teachers with equivalent years of service has been there at least my entire employment history, probably much longer. With regards to 89.3, I just want to say really briefly, laws have function. The function is to ensure fairness and to ensure justice. And my right to self-organize, if it doesn't include the expectation, the requirement, whatever legal word I don't know to say, it has to include the requirement for the laws to be followed. It has to include it. Minus that, there are no laws. The shepherd and the wolf can decide to eat half the sheep if they want. And the laws are intended to be followed. And in this case, since my complaint was the premise of the majority of my testimony, my complaint, to be clear, is when the state and the union decide to not follow Section F correctly, they have both decided they are not going to follow the law. They didn't decide not to negotiate. Well, they did, but that is also a decision to ignore Chapter 89. And when both parties, now this is just a state right now, I'll say it again later on today, but when both parties agree not follow the law, that derails the train that is collective bargaining. It derails.
I'm sorry. Can I just object? No disrespect, but he's testified to this. He's not addressing anything specifically. He's giving legal conclusions. I understand his points. He's already testified to it. Now it's just becoming duplicative, so I'd object to this line of testimony.
Yeah, I'm gonna,
Okay.
I'm gonna sustain that objection, Mr. Reid. So if you can limit your comments to the questions by Mr. Takei and Mr. Alapa. We recognize your testimony that you've previously given.
No more questions.
Mr. Takei, any follow-up questions?
No follow-up questions. Thank you.
Mr. Alapa?
Nothing, thank you.
And Mr. Reid, you're excused.
No.
Thank you.
Do I give this back to you? I believe this was yours.
Thank you.
And do I keep this? And the voting is yours?
Oh, I'm sorry, Mr. Reid. My fault. Yeah, you're back. Board Member Moipono, do you have any questions for Mr. Reid?
No, I don't. Thank you.
Board Chair Oshiro?
Yeah, I do. Mr. Reid, you know, in your testimony during the examination by Mr. Takei, you may have gotten confused because you're not a legally trained person or attorney, although you may have spent time on the internet. But I just wanted to understand that I believe it's self-evident in the record that you're saying that the employer did not comply with chapter 89-9 F2. Is that a correct understanding?
Yes.
I think there was a discussion about standing to bring a claim under chapter 89.
Yep.
And that's inclusive of that provision, but this particular provision of 89 F2 was part of your
Yes.
initial.
Yes.
Another one I want to make sure, I've heard a little about equal protection under the US federal constitution, or amendment, 14th amendment. That's not being pled in your case.
No, it's not.
Yeah, I'm nothing further.
Mr. Reid, I do have a couple of questions for you. And one is, I believe it's Employer Exhibit 36, which is related to Article 20, Section 3, if you can look at that.
Yes, I'm here.
And so you recognize this document?
Yes, 36, yes.
Okay.
Well, it's hard to read the dates. Is revised 6/1/17.
27, this is effective school year 2017, 2018.
Yeah.
Is that the year you were hired? by
Yes.
the deal? And is this a document that's put out by the Department of Education?
Yes, it is on the web. It's on the teacher recruitment website.
And then there's a section there that says experience credit, which relates back to Article 20, right? You see that?
Yes.
And under experience credit, the first sentence is experience must be officially verified before being credited and must have been in a recognized K-12 public or private school.
Yes.
Right. And then it talks about certain military experience for 4 years that can be combined for a salary credit for a maximum of 6 years.
Yes.
And that the verification of experience credit must be by the former employer and must be received within the current school year. See that?
Yes.
Okay. Was it ever your understanding that reading this, is there any mention that the 6 years or credit for the 6 years only applies to your initial hire?
No, it says I received salary credit. And it doesn't say temporary one time. Because I get credit.
Does it say if you read it, you're understanding that the verification of the employment has to be done within the year of your initial hire.
Yes,
Well, look at the last sentence again. Does that say it has to be done within the initial year of your hire? Doesn't it say within the current school year?
yeah, by the former employer must be received within the current school year, yes.
So it doesn't say the initial year of your hire, correct?
Correct, yes, that's correct, it says the current school year, yes.
I think you have nothing further. Mr. Takei, you have any follow-up question?
No, no question.
Mr. Alapo?
Nothing, thank you.
Board members, any questions based upon mine? Board member Moipono?
No, I don't have any questions. Thank you.
And I apologize for forgetting about you the first go around.
Oh, that's okay. I didn't have any questions, so don't worry.
Board Chair Oshiro?
No further question, thank you.
And I don't have any further questions, so now this time I'm correct in excusing you, Mr.
Thank
Reid.
you,
Thank
thank
you
you.
very much.
We'll see you again, but I'll go away for now. Stay.
Thank you.
Mr. Takei, I would assume that you don't want to start with a witness and question them for 5 minutes before we break for lunch.
Not for 5.
Okay. Okay, with that being said, we'll take our lunch recess and we'll return at 1:30. We'll stand in adjournment until then.
Yeah,
Thank
I
you.
think. On changes.